The heightened deadlines for briefings in the case of Ripple versus the SEC have laid the groundwork for the subsequent legal transaction. In the ongoing dispute between Ripple and the Securities and Exchange Commission (SEC), a confrontation has entered a critical phase with the notification of revised deadlines for remedies briefings. This represents a significant breakthrough in the fight. A significant new development in their continuous conflict with one another has occurred as a result of this. Attorney James Kyan drew attention to the fact that the Securities and Exchange Commission's SEC opening brief is now due on March 22nd. This was one of the remarkable insights that he supplied regarding the new schedule. Immediately after this, on April 22nd, the opposition brief for Ripple will be presented, and on May 6th, the reply brief for the SEC will be presented. All of this is in addition to the fact that both sides are now working their way through a number of deadline extensions. It is because of this amended calendar that the complexity and intensity of the legal processes that are currently being carried out are brought to light. These proceedings are causing the Ripple to be extended in comparison to the set that would take place in the subsequent step. It was in February that Ripple was granted permission to extend the duration of the remedies-related discovery that they had previously requested. It was requested that this extension be granted in order to accommodate the time that is necessary to analyze documents that were recently supplied and to finish the briefing that is associated with remedies. Furthermore, the Securities and Exchange Commission's request for an extension of time was granted at the beginning of March. This was in addition to the fact that the request was submitted. This suggests that the legal proceedings will continue, with both parties exerting a great deal of effort to fulfill their respective duties within the restrictions of the time frame established by the court. Solicitors who are involved in legal analysis will be considered. An attorney by the name of Bill Morgan has asserted that the Securities and Exchange Commission has a limited understanding of investment contracts that are associated with crypto assets. During the past 24 hours, the trading volume of XRP has decreased by 40%, and the price of XRP has experienced a minor reduction, decreasing by more than 2% to 6 cents as a result of this. John D. Fillon emphasizes that the Securities and Exchange Commission is unable to argue the non-security status of XRP, which was determined by Judge Torres of the SEC regarding fines for sales of XRP to institutional investors. This decision was made in response to a complaint that was filed under Section 5 of the United States Securities Act. Individuals who are involved in the market continue to hold a bullish outlook since they believe that the price will most likely rise to $2 this year. On the other hand, this increase is subject to the outcome of the ongoing lawsuit that the SEC filed, for instance. As a result of the recent increases in the XRP market, traders have begun opening calls for 9 cents, which symbolizes their estimation of the price fluctuations that are likely to occur in the future. According to the data from Verbit Options, which demonstrates that faith is growing, the market as a whole is eagerly anticipating the final decision that Judge Torres will pronounce at the same moment. The Securities and Exchange Commission (SEC) has communicated with the court in an official letter, noting that they do not expect to oppose the status of XRP by the time the deadline for remedies-related brief approaches on March 22nd. This statement was made in the context of the court's proceedings. It is anticipated that by this time, the point of inflection for the direction of the XRP price and the bullishness of the cryptocurrency market as a whole will have been established. Ripple and the Securities and Exchange Commission (SEC) have been involved in a dispute that may soon be settled. The legal challenges that were launched against Ripple Labs by the Securities and Exchange Commission (SEC) have been unsuccessful yet. Judges have finally found in favor of Ripple solicitors on a variety of grounds. This is the case, despite the fact that some of the challenges have been unsuccessful. The case in which the Securities and Exchange Commission (SEC) dropped charges against Ripple executives Brad Garlinghouse and Chris Larson is, for example, one of these points. Empower Oversight is putting pressure on the Securities and Exchange Commission (SEC) and the Office of Inspector General (I) to finish their investigation into the SEC's bias against cryptocurrency in Ripple. The investigation is centered on former SEC Director William Hinman, who is the subject of attention. The outcome of the dispute between the SEC and Ripple Labs will depend on a number of factors, one of which is the outcome of the Inspector General's office's investigation. In the XRP dispute, the United States Securities and Exchange Commission did not grant any extra authority in order to demonstrate that transactions on the secondary market are securities. This is an interesting fact to take into consideration. This is because, according to the Ho test, they are considered investment contracts. This is the reason why this is the case. The Securities and Exchange Commission (SEC) promptly issued a default judgment by the court as soon as the lawsuits against Binance and Coinbase were filed. This is indicative of the SEC's continuous attitude, which is arbitrary and capricious. There was opposition to the move from members of the community that uses the SEC currency, as well as from legal professionals, which may also be of interest to you. Judge Torres issued an order giving the Securities and Exchange Commission (SEC) an additional week to prepare for the opening brief regarding remedies. As a result of this judgment, Bitcoin exchange-traded funds experienced inflows of $870 million. A new set of dates for the XRP lawsuit has been established consequence of this verdict. The following is a compilation of the revised timetables for the Securities and Exchange Commission and Ripple companies. As a direct preliminary summary of potential solutions dealing with the matter at hand, discovery papers were made available by the Securities and Exchange Commission (SEC) on March 22nd. As of April 22nd, these papers have been published. There is still time for Ripple to file its opposition to the brief before the deadline. Attorney Bill Morgan claims that the Securities and Exchange Commission (SEC) has until May 6th to submit its response to Ripple, which is the deadline. There is still time for Ripple to file its opposition before the deadline. The interpretation of investment contracts concerning crypto assets that are provided by the Securities and Exchange Commission is weak, in addition to John Deaton, which is symptomatic of a decreased interest among traders in the meantime. Market participants are optimistic that the price of XRP could reach $2 this year. The final judgment has the potential to set off a tremendous rise given that the price of XRP has not seen much of an increase as a result of the SEC litigation. This is due to the fact that the price of XRP has risen above 7 cents this week. That is all now.